So here we are, edging in on October. It's what, the 4th today, 5th today, I think. And it's been pretty bleak weather the last couple of days. I guess most people, campers, have sort of wrapped it up now at Knights Beach for the season for 2021. Time to think about your winter activities and so on. But anyway, so this is just questions I have, and hopefully get an answer to at some point in time. But going back to December 4th, 2019, it was right around then that Barry Yellen, acting for Knights Beach Resort, served me with a libel and slander notice. Now that's just a notice that says what their complaint is, what they're complaining about, what they want you to do, not do, stop doing, whatever. That doesn't mean that notice doesn't say you're going to court. It's just telling you what their demands are. That's what a notice is. Roughly put, I'm sure Barry will be shaking his head right now, but something to that extent. But in a very detailed document, Mr. Yellen pointed out his client's concerns, and in a nutshell, he told me to remove my comments from the World Wide Web, to cease and desist immediately. The claim is my comments are outrageous, offensive, and baseless. I'm quoting there. When I searched outrageous, a little Google search there, I mostly got Don Trump comments. Lots of times you'll see people referring to Donald Trump as outrageous. I didn't find a legal problem with being outrageous. Definitely offensive. I mean, get that, agree with that completely, but it's not libel. Then there's baseless. So this is where my question, we start edging in on my question a little bit. Baseless. Baseless would mean that Mr. Yellen knows for a fact that what I'm saying is not true. So we've gone now from what I'm saying makes no difference whether it's true or false. Unfortunately, this is the law. So if I say something libelous or derogatory about Knights Beach Resort or the people employed by or owners of Knights Beach Resort, then that's libelous slander. It's a no-no. It doesn't matter under the law whether what I'm saying is truthful or not, unless I can absolutely prove it's truthful. But if I can't prove it beyond a shadow of a doubt, and a conversation just between a small group of people is very difficult to prove, obviously. And so it is still libelous in that sense. But Mr. Yellen's claim is it's also baseless. And I'm thinking to myself, well, Mr. Yellen wasn't present for the conversations that I'm talking about. He had not been even contacted yet to deal with myself or my friend Karen at that point. So his saying that it's baseless, the only way he can claim it's baseless is on the word of his client, Knights Beach Resort and Marlene. I say they said something that I'm claiming in my videos. They say they didn't. But either way, Mr. Yellen wasn't in the room. He cannot say beyond a doubt whether his client lied or I'm lying. But he does infer with his statements, and I'm using that word infer, very politely, that I'm a liar. Which makes me wonder then, isn't that libel on the part of Mr. Yellen? Now, Mr. Yellen can call me a liar in court. As technically I could call him a liar in court, because once you're in court, the libel rules don't apply within the courtroom itself. But we're not talking about that yet. We haven't been to court yet. This is Mr. Yellen in a written statement, which is a public statement, saying that I am this whole claim is totally available to the public, and he's basically calling me a liar. And yet, unlike where if I insinuate, and I'm not saying it right now, but if I insinuate that Marlene Allen is a liar, I could say it, from my point of view, I could say it that it's true because I was present in the room. I was there for the conversation. It's not hearsay. It's this first person. I was there. Mr. Young was not. So I don't, I can claim that what I'm saying is the truth, but I still have to be able to prove that. Mr. Young, he can't prove it at all because the claim wasn't there. So that tells me, or my question becomes, so is it that Mr. Yellen is not telling the truth? So what I've written here is, I ask these questions for the simple reason that lawyers make these blanket statements accusing other people of lying on behalf of their clients without having been present at the time of the incident. Maybe I'm splitting hairs here, no pun intended, but shouldn't a lawyer say, according to my client, since he was not present? He's not part of this complaint. He's acting on behalf of. Shouldn't they admit they have no idea who is telling the truth? Anyway, that aside, the threatening letter was sent to me. So, as I've said in the past, I removed all the comments as requested. The letter of claim said, quoting here, should you fail to comply with all the foregoing requests, we will commence legal proceedings against you, seeking damages and cost in the highest allowable scale. So they asked me to remove the offending comments, and that's what I did. I removed what they called offending libelous comments that weren't libelous comments, but I did it anyway, just as requested. Now the other thing is they also wanted me to publish an apology. So which I did not do. So with the libel remarks removed, I am meeting the demands made by Mr. Young in his claim, except for the apology. And they demand I make no future dissemination or defamatory comments. So I've been very careful in all my videos to make sure any of the comments were not defamatory. They may be, I am only telling you the story of exactly what happened to my friend and myself. They also demanded I not make any other future comments, quoting there. I don't think that you can really tell someone they're not allowed to make a comment. We'll talk about that some other time. So where did I fail to comply? You can't go after someone just for a comment. They did ask for an apology, so I did fail to comply by not offering an apology. Anyway, when I received the documents that we were going to court, I gotta tell you, I was actually a little surprised. I complied with all the points that they had made in their claim. They asked me to remove all the comments, and I did remove all of them. But essentially, we're not going to court because I didn't apologize. He's not saying that at all. He's saying we're going to court because of my defamatory statements, even though I removed the defamatory statements per his request. If you don't remove the statements, we will go to court. Well, I did remove the statements, so you would make the assumption from that we're not going to court. But we are. Kind of weird. Yeah, it's a little head scratching why we're going to court. We're going to court over, I've never had a conversation since all this happened with Edward Wasserman, who is the CEO of NightSpeech. Edward has never spoken, never asked anything of me, or offered anything to me, or threatened me, or anything. There was no communication at all. Zero. Absolutely zero communication. So, I would look forward to that, but I'm assuming that's never going to happen. A couple of other things I want to talk about, not today, but curious to see where they'll go in the future. Curious to see, I'm also very curious as to why the existing tenants have been so complacent with NightSpeech, but again, we'll go there down the road. So. Anyway, for now, signing off, and everybody have a great day, even though it's really bleak and horrible out there, and everybody stay safe, okay?